I'm Dean Luke. I'm professor of economics, and I'm also a director of the Natural Resources Governance Program at the Ostrom Workshop. So on behalf of the workshop and the law school, I want to welcome you to the second annual Ostrom Lecture on Environmental Policy to be given by Barton Buzz Thompson. We'll call him Buzz from now on. He's off to my left. He's a very distinguished legal scholar. His talk, Civil Wars, as you can see, the challenges of interstate waterways, I think will explore both the future of environmental policy and its path. And I think you'll also see some links to Eleanor Ostrom and her colleagues here at IU over the past years as well. So Buzz is currently the Robert E. Paradise, a professor of natural resources law and a senior fellow at the Woods Institute for the Environment at Stanford Law School. He's one of the world's leading scholars in environmental and natural resource law and policy. He's a native of California. He's a fourth generation Californian, I was just told. He has 3 degrees from Stanford. He was a Supreme Court clerk to Chief Justice Rehnquist. He's written zillions of articles. He served also as a special master in the case Montana versus Wyoming, which was a water dispute over interstate water. And he's lectured at many universities around the US and around the world. So despite all these fancy California connections and achievements, I want to report he was right at home at Nick's at the Hoosier Room the other night on his very first evening in Bloomington. So before we start, and I'll just tell you how we're going to do this, just want to thank the workshop staff, Allison Sturgeon, David Price in particular, and Rob Fishman at the law school also for hosting the event. So Professor Thompson will speak for 45 minutes, then I'll sort of cut him off, and then he'll take questions from you, and he'll just point out people. And then we have a reception in the faculty lounge, which I believe is 3rd floor. Yeah, so we'll go upstairs. We have a reception there for an hour. You can visit him there as well. The lecture is being live streamed, so behave yourselves. And it'll also be archived as a podcast. And so please welcome Buzz Thompson.
Okay, so the first thing is on the screen, what you see is actually a picture of the Colorado River right when it's entering the Grand Canyon. So it's leaving the state of Colorado and moving into the state of Arizona. I looked around on the internet when I was putting together this particular presentation, hoping I would find a picture of a river with a sign along it that would say, like, you are leaving the state of Colorado or welcome to the state of Arizona. I was unable to find anything of that nature, so this is sort of the closest I was able to come. So what I want to talk about today is actually an old topic. It's an important current topic, and I think it will be a topic for many generations to come. And that is, how do we manage interstate waterways in the United States? This is relevant not only to the United States, but it's relevant to all of the federal countries around the world, of which there are approximately 25, where you have similar issues of how do you actually divide the waters between the subunits within those particular governments. So I want to start out by thanking both the workshop and the law school and Dean for inviting me to come and give this particular presentation. I was really pleased to be invited to come and give the Ostrom lecture on environmental policy. Number one, because Lynn Ostrom's work has been highly influential on my own. It was in 2011 that Lynn Ostrom actually came to Stanford and gave the Tanner lectures. And the second of the 2 Tanner lectures was on the very first article in the American Economic Review. It was an article by Catherine Kamen entitled "Some Unsettled Problems of Irrigation." And I love the fact that the very first article in the American Economic Review was not only by a female economist, but it was also on water resources. And if you go to the very first issue of the Stanford Law Review, you will find that the very first article in that was on groundwater issues. So based on just these 2 first articles of important journals, you can easily surmise that water is the most critical topic around. And I tried to choose a topic here that I thought that Lynn Ostrom would appreciate, because it's a topic that's about common property resources. Interstate rivers are rivalrous in that The more one state takes, the less another state can have. And it's also very difficult to exclude unless you have some type of an institutional structure dividing the water between or among the states. And in fact, there have been a number of articles written over the last 10 years using either the IAD or the SES framework to look specifically in this context at interstate compacts. And I want to mention them at the very beginning of the lecture because they're excellent articles. If you're interested in this subject, I would encourage you to read them. And I have found myself turning back to them and relying on them in putting together this particular presentation. And there are two people in particular who are involved in this, Adela Schlager and Tanya Heikala, who have done the most work in this particular area. So again, what I'm interested in are interstate waterways. 95% of all of the water that we utilize in the United States comes from an interstate waterway. And in fact, if you look at the state of Indiana, it's as true of Indiana as it is true of the rest of the United States. I don't know how well you can see it on that particular map, but interstate waterways for Indiana include the Illinois River, the Wabash River, the Ohio, the Great Lakes, of course, and then also one river that I don't see on this particular slide, which is the Maumee River. And as far as I can tell, looking at the watershed, virtually all watersheds in the state seem to be part of those larger interstate watersheds. Now, although there are interstate rivers throughout the United States, the major focus of the division of interstate waters, how do we actually allocate the waters of those rivers, has focused on the western United States, and for a good reason. And that is that if you run a line down through the panhandle of Oklahoma, the fabled 100th meridian, it's the area to the west of the 100th meridian, which is dry and therefore has historically had immense water shortages. So it is those interstate rivers to the west where most of the controversy has been historically. And furthermore, most of the controversy has concerned surface waterways, interstate surface waterways, even though many of our groundwater resources in the United States are also interstate in their character. Now, in the Western United States, I have to give a quick bow to John Wesley Powell, because if John Wesley Powell had gotten his way, we might not have had a problem with interstate waterways, at least in the Western United States, because in his report on the arid regions of the West in the late 19th century, one of the things that Powell suggested was that we actually manage our waterways in the Western United States based on watersheds, based on those rather than on the straight lines that we instead decided to draw on the map of the Western United States and somewhat audaciously create the various political jurisdictions that we have there. No one paid any attention, however, to John Wesley Powell, and therefore we still have that question that I want to focus on today, which is the problems involved in actually allocating the water of those interstate rivers. And this is an incredibly important issue today for several reasons. First of all, the controversies over those interstate rivers are growing, and they're growing in magnitude. This is actually a diagram which shows both in the past and projected in the future the total supply of water in the Colorado River and the demand for water in the Colorado River. And as you will see, actually, the supply of water in the Colorado River has been dropping over recent years. And this is yet another drought year coming up. At the same time, the demand has been increasing. And although this is a chart showing water demand and supply for the Colorado River, this is duplicated in rivers over and over again throughout the United States. As a result of climate change, we're finding that many of our rivers today have less water in them than 50 years ago. And the demand for the water in those rivers is growing as a result of economic and population growth throughout the Western United States. So we are seeing actually more civil wars, more battles over interstate rivers than we saw just 20 or 30 years ago. One of the best examples of that is it used to be that an interstate water dispute would make its way to the United States Supreme Court on average about once every 5 years. A year ago, if you had counted the total number of interstate water disputes before the United States Supreme Court right now, you would have found that there were 6 interstate water disputes before the Supreme Court. Historically, the major source of interstate original jurisdiction before the US Supreme Court were border disputes. Then it became oil and gas disputes. Today, it's water disputes. And not only are we seeing more water disputes than we saw before, but in addition to that, those water disputes are beginning to change in character. So we're beginning to see more water disputes in the eastern United States than we historically saw. Again, historically, they were almost all in the western United States, but in the past couple of years, several eastern water disputes have been filed before the United States Supreme Court. The major one that's before the court this particular term is Florida versus Georgia, which deal with the river systems that began in Alabama and Georgia and then flow down into Florida. And this particular dispute is interesting not only because, again, it's an example of an eastern dispute where historically there has been sufficient water that disputes generally didn't arise, but this is also a dispute that involves environmental claims to water. Again, historically, most water disputes were between states that were really interested in claiming as much water that they could divert from their rivers and then use for consumptive purposes. In Florida versus Georgia, the major concern is to make sure that there's sufficient water going down to the Florida Bay in order to support its oyster industry, as well as a number of endangered species that live both in the bay as well as in the river system. The other major dispute that's before the United States Supreme Court this year, we'll get an opinion by June, is a case called Mississippi versus Tennessee, which is the first interstate dispute before the Supreme Court that solely involves groundwater. In this particular case, you have Mississippi, which on this particular map, this is what's known as the Memphis sand aquifer, also sometimes known as the Sparta aquifer. And there's multiple states overlying that particular aquifer. But in this particular case, it's a complaint by Mississippi to Tennessee that's complaining that because of Memphis's growth, Memphis is pumping more and more water out of the aquifer. And according to Mississippi, basically pulling Mississippi's groundwater under and across the border. For those of you who are water experts, this is a truly peculiar case, only because Mississippi's argument is that all of the water on this side of that dotted line would remain there if it were not for what Memphis is doing. And that because Memphis is pumping the water, again, it's pulling the water underneath here, and it's basically a theft of that water by Tennessee, for which Mississippi is seeking compensation. So again, these disputes are moving east. These disputes are growing from simply surface water disputes to purely groundwater disputes. And the other thing that you've seen over the last 20 years or so is that these disputes never get fully resolved. We think we have killed off a dispute. We think we have settled a dispute. But then the dispute keeps coming back to the United States Supreme Court over and over and over again. And the best example of this is the North Platte River. The North Platte River was originally apportioned by the United States Supreme Court in 1945. It then came back to the US Supreme Court again in 1993. It then came back again in 1995. And most recently, it came back in the year 2001. And there are beginnings of stirrings again to suggest that this case might come back to the United States Supreme Court again. So what I'm trying to do here is to simply emphasize how important this particular topic is. You have a resource which constitutes 95% of all the water that we're utilizing in the United States, all of these interstate rivers. It's a common property resource. And what we're seeing is not resolution of these disputes, but the spreading of these disputes and the endless lives of these particular disputes. So what I want to do in the half hour or so that I have remaining in my time is basically to do several things. I want to start out by looking at the methods that we currently utilize to try to resolve these particular disputes and why they don't appear to be working. I then want to just briefly talk about whether or not there are other mechanisms that sort of are just below the surface that we actually are not looking at, and that as scholars that we should be focusing more attention on. I then want to come back to one situation where I think we're succeeding in actually avoiding civil wars. And then I'll come back at the very end for some potential pathways forward. So the very first approach that we have for resolving interstate water disputes is for the various states involved to go to the United States Supreme Court and seek what's known as an equitable apportionment. This is a situation where the United States Supreme Court, under its original jurisdiction, can hear cases brought by the states and can allocate the water of an interstate river between the states. The very first example of this is the case of Kansas versus Colorado, which dealt with the Arkansas River, or as some states like to refer to it as the Arkansas River. And in this particular case, you had Kansas, which was the downstream state in this particular situation. And they argued that they won under both the riparian doctrine and the prior appropriation doctrine, which, if you know anything about water, basically are all of the doctrines that we use in the United States. Kansas was a downstream state, so it argued that under the riparian rule of natural flow, the water should all flow to it, but it also was the first state to develop water, and therefore it also argued that it should win under prior appropriation. Colorado argued what's known as the Harmon Doctrine, which is, but the water all starts in Colorado. And if it all starts in Colorado, we should get that water. The Supreme Court, I think, started out on the right foot by declaring in this particular case that both of those states was wrong, that they would not announce a clear rule for how they were going to allocate water, but instead they would look at each case based on issues of fairness and equality, and divide the waters of the states, recognizing that all states are equal and that all are entitled to be treated justly. And the guy, by the way, at the lower right, anyone know who that is? Any of the law scholars here know who that is? It's Justice Josiah Brewer. And I bring that up only because the person who wrote the next big equitable apportionment case is this guy. Anyone who know that is? Huh? Okay, so that is Justice Willis Van Vandevetter. And the reason I bring this up is just a quick digression. No one on the United States Supreme Court ever wants to write these opinions. So they almost always get assigned to the justice who is either in the doghouse at the particular point in time or is not sufficiently brilliant to write anything other than original jurisdiction cases. So if you ever want to know about the other Supreme Court justices, you read the original jurisdiction cases. But Wyoming versus Colorado, which dealt with the Laramie River, I actually think then took a wrong foot, which is it moved away from just sort of notions of general equity and said in the Western United States, where most states follow a rule of prior appropriation, first in time, first in right, we're also going to allocate the waters of the western states based on prior appropriation. What that immediately does is it puts all of the risk on the states that are developed later. Because if there's any sort of a shortage, it's the states that develop first that get their water. And it becomes a very rigid rule that actually is not a particularly fair or just way of allocating water. But I'll come back to that in a moment, because what I want to talk about next is the case that I've been the special master on, which is the Montana versus Wyoming case. This is a case dealing with the Yellowstone River system, which begins in Wyoming and then defying the laws of gravity flows north into Montana. And no reason to actually fill you in on the particular facts of this particular case. But when I was serving as a special master in it, I noticed several pathologies, several problems that were quite clear in the case. The first one was that the case was all about distributional claiming. The only thing that the parties argued about the entire time that they were before me was how much water each state should get. They were never interested in the question of how might we be able to manage this particular river system in a way which would maximize the amount of water that could be utilized. There was no interest in enlarging the pie. It was all about how you would actually divide up the pie. And that's partly because that is all that the Supreme Court decides in equitable apportionment cases. It is all about an issue of who gets how much water. So again, first problem, it was all about claiming, very little about creating. An example of that was about halfway through the trial. I actually had the most recent head of the Montana Department of Water on the stand. And he started telling me about the years that he had spent trying to get the two sides, Montana and Wyoming, to sit down together and talk about how could you manage this river on an integrated basis in a way which, again, would actually expand the amount of water resources that you would be able to utilize. But what he said was he found that he was actually getting nowhere, and that particularly when the lawyers came in, that all talk about how you would expand things disappeared, and all the money that was actually allocated for that particular effort was reallocated to this particular lawsuit. And he actually broke down on the stand. I had to call a recess to let him recover from the fact that he thought he had been trying to do something good, to try to actually figure out how to manage this particular river on a more integrated basis, only to find that instead what the equitable apportionment action did was to drive people back towards claiming. And this distributional contest also affected the various water users. This is Edwin Mugley, one of the Montanans in the case. And people like this would show up at the courtroom every day. They would walk in, they would shake hands, even though they lived in Montana or Wyoming, because they were neighbors. But then when they came into the courtroom, they would sit on either side of the courtroom. They would sort themselves by their particular state. And although these are all just anecdotes, I think in many ways it helps to highlight some of the problems that we face in equitable apportionment actions. Now, the United States Supreme Court has had opportunities to actually try to change the tenor of equitable apportionment actions, and one of the best examples of this is in Colorado versus New Mexico, which deals with a river that virtually no one has ever heard of, the Vermejo River. In this particular case, New Mexico was already using 100% of the water from the Vermejo River. Colorado, however, thought it was entitled to some. And so it came to the United States Supreme Court on the basic argument that if we could just get New Mexico to conserve a little bit of water, then that would free up water for us to use in Colorado. And although the United States Supreme Court initially showed some interest in that, ultimately they concluded that no, that isn't quite the way in which the prior appropriation system should work. New Mexico was there first. New Mexico was using all the water, and therefore they allowed New Mexico to continue to use all of that water, even though it probably would not have cost New Mexico that much to actually conserve sufficient water so that there would also be water available for use in the state of Colorado. If they had done that, that would have been an example of creating, right? That would have been an example of trying to find a way of actually expanding the amount of water that was available for everyone to use. But the Supreme Court very quickly shut that down and went back to a very rigid prior appropriation concept of how you actually allocate water. So when I look at the equitable apportionment concept, these are the various problems that I see with it. The very first one is, yeah, it emphasizes distributional claiming. That is what you do before the United States Supreme Court. And it actually suppresses or kills off a concept that you would engage in any type of collaborative creation. A second aspect, which I haven't mentioned so far, is the way in which these cases are actually litigated. They are litigated by the states. The states stand in the shoes of all of the various water users within the state. So use the legal term, the states are acting as parents patriae for their water users. And in fact, water users have frequently tried to intervene in these cases and actually be able to have a direct voice in these cases before the United States Supreme Court. And the United States Supreme Court has largely turned them down and said, no, we are going to hear from the states. We're not going to hear from the water users themselves. What this does is it means that you have the states arguing and the actual people who are using the water, the stakeholders, who might actually have the best knowledge of how you could manage the rivers in a way which could maximize water use, are excluded from the litigation. If they're going to participate, they have to participate as amicus. As I suggested earlier, I think these cases also undermine trust between the parties. At the end of the Montana versus Wyoming case, I had no impression that Montana and Wyoming were any closer to being working partners than they were at the very beginning of the case. These cases present a litigation straitjacket. They are virtually impossible for states to get out of once they have filed these pieces of litigation. By the end of my case, the case involved only a tiny amount of water, about 1,500 acre feet, which for those of you who know anything about water is virtually no water whatsoever. And yet the parties could not settle the case. I asked them at the final hearing, why couldn't you settle? And the only answer I got was, Your Honor, it's water in the West. We cannot settle questions about water in the West. And what happens is once you get in this claiming mode, it's very difficult for an attorney general to settle a case and to say, well, we're actually, if I'm the attorney general for Montana, I'm going to let Wyoming have a little bit more water because you will get unelected the next time you run for attorney general. Much better to let the special master of the U.S. Supreme Court rule against you because you can then blame the stupid special master for coming up with that particular decision. And then finally, you have the typical litigation problems. These are costly. These are lengthy. Montana versus Wyoming, it took 10 years for that particular case to be resolved. And that was a relatively fast case of equitable apportionment. So equitable apportionment doesn't work very well. What about interstate compacts? Interstate compacts are where the states get together. They agree on how they're going to divide up the water. And under the United States Constitution, formal agreements amongst the states are compacts and they have to be approved by the United States Congress. The very first interstate compact was over the Colorado River. You actually see the various negotiators for the Colorado River Compact in this particular picture. And there is one sort of famous person in this picture, actually two people who, from a water perspective, are famous. The first one is, Herbert Hoover. He was the person who actually brought all the parties together in order to negotiate the compact. And then the other person, this guy here, Delph Carpenter, who was a Coloradan, and he was, if you actually stop to think about all those cases I talked about earlier, think about how many of them Colorado was a party to. And Delph Carpenter thought, rather than going to the United States Supreme Court and having the states battle over this, doesn't it make a lot more sense that the stakeholders get together and figure out how you're actually going to manage these various rivers? So these are all the various interstate compacts dealing with water in the United States today. Again, one of the things that I found sort of interesting, if you look at the state of Indiana, you actually have 3 compacts that deal with water that you're a party to. You're a party to the Great Lakes Compact. You're a party to the Great Lakes St. Lawrence River Water Resources Compact. But what I never even heard of, you're part of the Wabash Valley Compact, which was a compact that actually encouraged the development of the Wabash Valley. And one of the provisions of it is that this particular compact commission, which as far as I can tell, no longer has any commissioners. It's still on the book, but no one has actually appointed a commissioner for the last 45 years. That this particular compact was also supposed to determine the water needs for the Wabash Valley and then ensure that all of the states had adequate water resources. But the compacts that really matter here are these compacts in the Southwest and Southern United States, because those are the ones that resolve the type of cases that I talked about earlier. These type of interstate compacts caught on really quickly. From 1922 with the Colorado River Compact, led on by Delph Carpenter from Colorado. You had approximately in the western United States, these are the major ones, but in the first 50 years, you had about 20 compacts negotiated during this period of time. And there were a variety of things that I think encouraged the adoptions of compacts at this particular point in time. First thing was everyone at this stage wanted a federal reservoir. You wanted a reservoir to store your water. And the federal government took the sensible position that before they built you a reservoir, the federal government was in the business of doing it at that particular point in time, they wanted you to sign a compact that would actually divide up the waters so that if they built a reservoir, that reservoir would not then end up in the middle of an interstate water dispute. So the federal government basically said, you want a reservoir, you first have to negotiate a compact. Second of all, you were going to get a reservoir if you entered into the compact, which made the compact a little bit easier to negotiate because you actually were going to be able to store water. Water was going to be in greater supply as a result of the federal largesse. Third thing was you had Delph Carpenter out there, and if we just go back for a second, all of those various compacts on the left in italics, those are all Colorado-based compacts. Delph Carpenter was really a proselytizer. He got out there, made sure people entered into these compacts. Even with all these various incentives, these compacts took a long time to negotiate, and they frequently succeeded only because a lot of difficult issues were jettisoned in the process. But this is the interesting thing to me. If you actually look at how many compacts have been negotiated, which is the blue, and if you look at how many compacts have been amended, which is red, we had a lot of compacts negotiated in this period between 1921 and 1960. Very few in the 1961, 1980. We've had no new compacts since 1972. And think about it, 1972 is about the time that the federal government really got out of the business of building new reservoirs. So the moment that incentive disappears, the moment that those reservoirs, which are going to make it easier for you to get the water that you're going to divide up, once that disappears, our compacts disappear. And not only do the compacts disappear, but even though people are disagreeing every day over what these compacts mean, we also are getting virtually no amendments of these particular compacts. So the incentives that actually drove these compacts has been removed, and in the process, this particular tool for resolving interstate compacts have also disappeared. I also think that if you actually look at these compacts are flawed in a variety of ways. First of all, again, they're largely allocated. Very few of these compacts do anything, again, to try to increase the size of the pie that's being divided. Instead, they are almost all about how do you divide up the waters of an interstate river or waterway. Second of all, their assumption is that the world is very stationary. So they, majority of them actually have a fixed allocation of water, which means that whoever is the state with that fixed allocation does really well during a period of climate change, and other states lose out. They ignored groundwater because groundwater wasn't a major issue at the time. They have no sort of flexibility mechanisms built into them, such as interstate water markets. The commissions are largely ineffective. Now, there's been a study that shows actually those commissions resolve more disputes than we probably think they do. But when it really comes down to important distributional and management issues, the commissions tend to be ineffective. They are state and federal officials. They are not the people who are actually using the water. They are, again, a top-down approach towards managing these rivers. They generally require unanimous votes, so the commissions actually can't decide anything unless everybody on the commissions agree. They have restricted authority, and they actually even have limited authority to collect various types of data. Furthermore, most of these compacts provide no opportunity for customization. In the Western United States, one thing that has happened in a lot of different states is that legislatures have authorized local water districts, and those local water districts frequently customize the way in which water is actually managed. You do not find interstate water districts. You do not find these compacts permitting the local stakeholders to come together and form their own individual organizations that might adopt different rules. Virtually no compact provides for any type of amendment other than to go back, renegotiate them all, and most compacts took 15 years to negotiate to begin with. The only thing you can do if you want to amend it, go back, negotiate for another 15 years, get the approval of the governors and the legislatures of those states, and then the United States Congress again. And the only way in which you can enforce these is by, once again, going back to the United States Supreme Court and having the type of proceeding which I mentioned earlier. And interestingly enough, one of the things that the United States Supreme Court has been willing to do in these cases, they will sometimes revise operational rules. So you can have a compact that maybe says nothing about groundwater. Sometimes the Supreme Court will step in and say, even though it doesn't mention groundwater, it includes groundwater in it. Should include groundwater, and therefore they'll find a way of actually reading that in. But what the Supreme Court doesn't seem willing to do is to ever be willing to rethink any of the sort of constitutional rules. So the picture on the right is the Pecos River Compact Commission. It has a rule that every state gets a vote, and you have to have a majority vote. Problem is that there's an even number of states, and so those states tend to always deadlock. The federal government has a representative on the commission, but that person can't vote, so can't break a tie. The special master in a case dealing with the Pecos River suggested to the United States Supreme Court, why don't we, as part of our equitable relief, say that the federal representative can vote? And if we do that, then maybe that would actually improve the operations of this particular commission. The Supreme Court said, no, although we'll sometimes take a compact that says nothing about groundwater and say it actually applies to groundwater, we can't say that the federal government can have a vote here because that would be going against the wishes of the states. the states didn't say the federal government had a vote, and therefore we will not give the federal government a vote. So for some reason, the Supreme Court seems more willing to get in those operational rules than the constitutional rules, where I think they feel as if they're getting more involved in issues of federalism. As a result of all of this, we have a high rate of disputes over compacts. If you take the 14 major compacts in the Western United States, a majority of them have actually ended up before the United States Supreme Court because the parties couldn't agree. In my case, dealing with the Yellowstone River, even though at the time that it went before the Supreme Court, the compact was 57 years old, the states had never agreed as to what the compact meant regarding anything. They had never been able to reach agreement on any managerial issue under the Yellowstone River Compact. And maybe sort of re-emphasizing some of the points I made earlier. First of all, if you look at those compacts that have fixed or prior appropriation systems embodied in them, and again, I think that's one that does not spread the risk, but imposes the risk on one party, versus compacts that have a proportional system that in a period of drought, everybody cuts back equally. Not surprisingly, the blue shows the number of compacts that have been in dispute. The red shows those that have not been in disputes. You'll see virtually all of those compacts have ended up before the United States Supreme Court. Virtually none of those that have proportional systems. Similarly, I think one of the problems that we have with the federal government conditioning the provision of federal funding for a reservoir on the negotiation of the compact, this drove the states into entering into any compact. Every single compact that has been before the United States Supreme Court is one that was driven by the desire to get a water project rather than by, for example, an actual conflict between the states. And they had to sit down and figure out how are you going to actually resolve that. So yeah, I don't think these flaws should be surprising. We have, they're all negotiated within the shadow of a poor legal rule, prior appropriation. Most of them were shotgun marriages where the federal government said you had to negotiate a compact. Particularly in those compacts, there was little experience as to how you would actually divide up the water because it wasn't an issue at that particular point in time. Most of them have very broad boundaries. The Yellowstone River Compact involves 6 major rivers, and they're all treated the same. So there's no real customization in these compacts. They were all top-down negotiations by engineers who were told to sit down and negotiate a compact, and they were negotiated under high data uncertainty. So really quickly, and then I'm gonna start running out of time.
Yeah, you are.
Yeah, so I'll tell you what, I'm not gonna deal with that. Instead, what I'm gonna just quickly do is talk about the Colorado River. Colorado River is frequently given an example of a system that isn't supposed to work. I actually think it's a success story. Colorado River goes through, 7 different states. You'll see it here. One of the key elements here is Lake Mead. It stores water for California, Nevada, and Arizona. This is Lake Mead today. Key thing here is to notice this line here. The water used to be up here. Every year the water is dropping in Lake Mead. Every year there's less water in Lake Mead than there was when Lake Mead was originally filled. In Arizona versus California, though, in 1963, Arizona and California went before the court for an equitable apportionment. If the Supreme Court had followed its case law, it would have used a prior appropriation system to allocate the water between California and Arizona. Most of the water would have gone to California. The Supreme Court felt very uncomfortable with that, so they made something up. They claimed that Congress had actually previously allocated the water and given the Federal Bureau of Reclamation, part of the Department of the Interior, the authority to actually manage who got what water in the Colorado River. What that meant was that suddenly you had a federal nudge. You had a Department of Interior who could basically say, we can tell you how we're going to divide up the water, but you guys can decide how to do it yourself. Total flexible apportionment. We don't have a prior appropriation rule here. We have a rule that whatever the states want to do, whether the federal government be willing to step in and actually take action if they don't. It actually led to multiple competing fora. Everybody started creating their own entities to try to figure out how we could better manage the Colorado River. There was active shareholder involvement, and we weren't dealing with a compact of the Supreme Court, so we had a very expedited process. And as a result, we have market mechanisms on the Colorado River. We have what are known as shortage guidelines, which actually now permit the various stakeholders to store water if they don't want to use all of their water in a given year. That frequently is not the case under other compacts. We have something called the California Quantification Settlement Agreement, which also permits various types of trades of water within California. We've reached treaty agreements with Mexico, which have, for example, actually permitted us to flood the Colorado River south of the border. I put this picture up here because these are Mexicans who are actually celebrating the fact that the Colorado River has gotten down into Baja California for the first time in 25 years. And we have a new draft contingency plan that Arizona might or might not agree to, but if they agree to it, it will again be an example of sort of flexible management of this particular system. And I think it's largely all because of an accident. So here are some options, just sort of going forward. Go through them very quickly and then I'll take questions. On the Supreme Court, equitable apportionment. One thing, there's no reason why we couldn't bifurcate proceedings. Start out with the creating function. Start out by asking the states, what are your ideas for actually maximizing the amount of water that could be utilized in this river? How can we integrate management here in order to expand the pie and then get to the question of distribution? We could involve stakeholders more actively than we have in the past, and the court could eschew set formulas and instead really get back to this original principle that water should be allocated on a more equitable basis. In terms of compact disputes, one thing the court could do would be to say, before you come to us, mediate. As part of that mediation, we want you to try to think about how you might be able to resolve this dispute through mechanisms other than simply creating. Be willing to reform constitutional rules. The remedies here are equitable. And also consider legal reformation, where states can come to and actually ask for reformation of the compacts that are before them. Federal government, could they go back, should they go back and encourage compacts? They're not going to build new reservoirs. I wouldn't endorse that. But they could provide funding for studies that would be open to all stakeholders in the interstate river watersheds. And then if they want to, they could say, hey, if you guys come up with a compact that meets certain requirements, the federal government will comply with that compact, will agree with that compact. And furthermore, maybe we'll also delegate our regulatory authority under, for example, the Endangered Species Act for this particular watershed. And again, Rob's smiling, but this would all have to be approved by Congress. Maybe that doesn't help today, but in the future that would help. Again, they actually, in some cases, can vote on some of these commissions, but the federal government's general position is they don't vote because they don't want to end up in the middle of these disputes. Maybe the federal government should. And could Congress create Article 1 panels that would actually be better at resolving these disputes than the United States Supreme Court? And can they do that constitutionally? Finally, potential state and compact commission options more actively involve their stakeholders than they do now. Encourage flexibility through market mechanisms in particular. Allow local customizations. Encourage, particularly in these large watersheds, individual water users to come together in districts in order to actually manage the water. And finally, and this would have gotten to what was below the surface, utilize administrative agreements. All of the agreements so far on interstate rivers have been compacts. Those are very tough to negotiate, and you have to go to Congress to get them approved. And then once they're approved, if you amend them, you have to go back to Congress again. There's another mechanism, which is just do this administratively. It doesn't necessarily have the same authority, but I think you could do it much faster and much simpler. So with that, I took a little bit more time than you told me to, Dean, but I'll take any questions or comments.
Oh, that's great. Thank you very much. I'll let you pick questions.
Okay.
Remind you that, yeah, we have 15 15 minutes of questions, and we'll have a reception upstairs. We'd also say that Buzz is in-house at the workshop tomorrow and for part of Friday, and easy to, you want to connect with him there. There's also a roundtable, very informal lunch thing at the workshop on Friday. You're all we need to connect with us to make sure that it's there.
Yeah.
But you're welcome to come.
Yeah, and unlike a lot of speakers, I actually encourage comments in addition to, to questions. So, if you have your own ideas, I'd love to hear.
So it's, my case, it's a question of, first of all, I really enjoyed your presentation. It was wonderful. I was trying to think, so why not selling water? So what one state cannot sell? So it doesn't matter what's the original allocation of property rights. That doesn't force you to use that water. You can sell that water to the other state, and see from that perspective, I would think, what's the transaction cost that block that, essentially? What would be one way to go? And the option is, if the problem is to maximize the pie, but if you're completely sure that you have property rights for some fraction, you can also negotiate with the price at which you are selling the water to the other state, so the other state collaborate in maximizing the pie. No?
Yeah.
So in some sense, what's the transaction cost there that is blocking this type of solutions? No?
Yeah. Okay. So there can be a lengthy answer to this, but let me make 2 or 3 points. The very first thing is that the very nature of equitable apportionment and interstate compacts have historically made this more difficult. And the reason is that they have encouraged the idea that each state gets a certain amount of water. All right? So it leads to this sort of notion that, take the lower basin of the Colorado River, which is California, Arizona, and Utah. And Nevada. It leads to the notion that California gets 4.4 million acre feet of water, and that's their water. And Arizona gets a set amount of water, and Utah gets a set amount of water. There was actually a case that the U.S. Supreme Court decided 2 years ago dealing with the Red River Compact, in which Texas was trying to bring water from Oklahoma over the border into Texas. And what Oklahoma said was basically, you can't do that. You are interfering with Oklahoma if you do that. And the United States Supreme Court agreed. So frequently, again, the whole effort to allocate the water between or among the states undermines the effort at interstate water markets. So the only way you can make sure that you can do that is by explicitly say in your compact that you can market water between the states. And at some point, I think it's going to be really important for the U.S. Supreme Court to say that from the standpoint of an equitable apportionment, where the court has done it, that there again, you can actually trade water between the states. So that's a primary answer. A secondary answer is water marketing is just difficult in the Western United States, period. It raises a number of difficult questions. But where that first question has been overcome, we have been able to get water markets actually developing. Interestingly enough, on the lower basin of the Colorado River, Arizona, which has not been using all of its water, has been storing that water in groundwater aquifers. And as part of these agreements, it now sells some of that water to the other lower basin states. So you have that first problem, which again, I think has to be part of the solution here. And then the second problem is just the general problem in the Western United States of water markets. Yeah, problem.
Suppose we amended the Constitution to allow these disputes to proceed in trial courts, right? That is part of the problem here is the institutional mismatch between the very head in the clouds appellate character of our Supreme Court justices and the fact-based disputes. Would that help, or does the special master system do just as good a job as the district courts could do?
Okay, so yeah, 2 or 3 things. First is you made an assumption, and your assumption is that we actually have to amend the Constitution in order to permit these cases to be brought before a trial court. Go back, take a look at Article 3 of the Constitution. Article 3 provides that the U.S. Supreme Court has original jurisdiction. It does not provide that the U.S. Supreme Court has original and exclusive jurisdiction. The exclusivity issue actually comes from Congress. Congress has provided that these states can only go to the United States Supreme Court. So it's even easier than you think. Congress could simply pass a law at this point that would say these type of interstate disputes could go to a district court. I actually think that would probably be a good idea. The special master process that the U.S. Supreme Court follows, maybe I should take a step back for any of you who don't understand the whole special master process. While these cases are within the exclusive and original jurisdiction of the U.S. Supreme Court, the Supreme Court is not a trial court. It does not like to sit and preside over a trial. So what the U.S. Supreme Court does is its very first step is it appoints a special master, somebody like me or a retired federal judge, to hear all the evidence and provide recommendations to the court. It's a bit of a, number one, it's a bit of a clunky process, because what happens is, I'll hear some motions, and at some point I decide this is something the U.S. Supreme Court should decide. And then I write a report to the U.S. Supreme Court. I file that report with the U.S. Supreme Court. If the states want to, they can file exceptions to my report, at which point the Supreme Court will then set it for an oral argument, hear it, decide it, and then send it back to me again. So this back and forth process, and each time there's a back and forth process, you lose 2 years of the proceeding. So it's a clunky, lengthy process. And although I hope I did a good job in the Montana versus Wyoming case, I was sort of worried. I mean, you're the states of Montana and Wyoming, and what happens with the Yellowstone River system is one of the most important things to your state. And who do you end up before? You end up before a professor from Stanford University, right? I mean, somehow I think if I were a state, I would want a real federal judge to be taking the evidence.
You and the Pennsylvania Republicans.
That's right. Yeah. Absolutely. So for all of those reasons, I actually don't see any reason why you couldn't follow the normal process. Now, the counter argument to it is that it means something that this is a case that starts and ends before the United States Supreme Court. The notion is I might be the person sitting there taking the evidence, but I'm constantly saying what the court will do. The argument is that it shows the parties how important this is, and that when you deal with these essential issues of federalism, it's only the U.S. Supreme Court that can ultimately decide the case. So that's the argument on the other side. But again, I would probably think about creating these Article 1 tribunals.
So I have a follow-up to Rob's question. I mean, could it be, do the Supreme Court justices benefit in any way from temporarily sitting as trial judges in these types of cases? Because they don't just always take the special master's report, although this seems that they do often. So, I'm thinking back to Justice Sotomayor's confirmation hearings.
Right.
When part of the idea of why she would, or why the Obama administration said she would make a wonderful justice, is she had district court experience. And that very practical, hands-on ability to take evidence and consider evidence is something that would be particularly useful as an appellate judge. So I'm wondering whether or not these compact cases have any benefit in that respect.
Yeah. So I do think there's a benefit of having justices serve as trial judges. Chief Justice Rehnquist used to always go out on circuit and sit occasionally as a trial court, because he just thought that was a valuable thing to do. The problem is that frequently these cases are, they're not your normal trial. Mine was a short trial. And mine, I think, lasted a total of 36 days. So what's that? That's about 2 months. And it's just hard for the Supreme Court justices to take off 2 months to actually try these cases. Some of them take a year or longer to try.
That's my point was slightly different, that when they get the case with the recommendation of a special master, just
Right.
having the capacity to make different findings of either fact or law or remedy, does that sort of get their trial judge juices flowing and only in the context of that particular case?
Yeah, I mean, that's an interesting question. So I'll just mention in the Montana versus Wyoming case, the third phase, as we were talking about earlier, was a remedies phase. Wyoming wanted the Supreme Court to resolve that on its own, rather than send it back to Mead for further proceedings. That might have been something that maybe one or two of the justices could have actually sat there and heard a limited amount of evidence upon which they could have decided the remedies, but they sent it to me instead to decide that. Dan.
So I'm wondering if we have not just states in the West, we have these semi-sovereign dependent nations. I'm wondering, do they get representation in these negotiations?
So
by the federal government or their own?
Yeah. So again, sort of several things on this. So for those of you who, I think you all understood what Dan was talking about, but you have Native American nations, and those Native American nations often have water claims to interstate rivers. So in the case of the Yellowstone River in Montana versus Wyoming, it was the Northern Cheyenne that had a water right. First thing is, it's another complication in the equitable apportionment process, because they are sovereign nations, which means they have sovereign immunity, and they do not have to waive that sovereign immunity in interstate water disputes. So as a result, the Northern Cheyenne were in my courtroom, and they participated as amicus, but they never waived their sovereign immunity, which meant I constantly had to try to figure out how to resolve individual issues without impacting the Native American water right, because I had no authority over them. And so that sort of constrained what I was actually able to, to do. So that's one problem that arises. The second thing is that generally they're not part of a compact. The compact is, again, generally among the states. And so you have this sort of two-step process. You have the negotiations between the states, and then you have negotiations later between the states and between the tribes. And that also means, rather than trying to think it all through together at the very beginning, it all gets separated out in a way which I think makes it more difficult to find effective and efficient solutions to the problems. So I think both of those are problems, and it would be nice to resolve them, but the problem is we can't resolve them so long as the tribes are sovereign nations, and that's what they are. So, yeah.
I know we've been talking a lot about water quantity today, but I was wondering if there's any kind of comparable body of case law or interstate compacts or anything about water quality happening right now. I'm especially kind of thinking like the boundary waters that, like the Ohio River, the Mississippi River, would seem to kind of fall through the cracks in the national and state water quality policies and things like that.
Yeah. So there's several interesting things there. The first is that there are a significant number of water quality compacts, and most of those compacts are in the eastern United States. You find this very interesting division. You have compacts in the west that are quantity. Quality is in the east. Some of those quality compacts deal with quantity. Virtually none of the quantity compacts deal with quality. The quality compacts in the east seem to work better. And if you actually look at the formulations of those compacts, they are very different than the Western compacts I showed you. So for example, they frequently have commissions that have their own regulatory authority and constitutional rules that actually permit sort of robust discussion and creative management. And I think one of the interesting questions that I'll be honest, I don't have a good answer for is why you see those significant differences. I think one of the reasons is on the quality side. Those are issues where the decision-making process is not simply distributional between the states. Instead, it's if you can promote good quality, it benefits your residents also. So there is much less in the way of claiming between the jurisdictions and an equal amount of how do we actually manage this system to improve everyone. But you do see these very different systems of compacts between the East and the West. And because the East work better, you don't tend to see the type of conflicts coming up to the United States Supreme Court. The big issue right now between most or before most of those quality compacts is fracking. And again, interesting enough, virtually all of them are permitting fracking within their jurisdictions. And so there's a lot of conflict, but it's not a conflict between the states. It's a conflict between environmentalists and the compact commissions.
Okay, I think we're gonna call it a great lecture, and hope you can join us upstairs. Thanks.